Well, good afternoon, everyone, and welcome to the October 3rd, 2023 Planning Commission Work Session. Ms. Adamwa.
Good afternoon, everyone. I think you have an agenda before you. We will be following this agenda. I've spoken with Assistant Attorney Jeff Miller, and he has agreed to give us a brief review of Robert's Rules of Order. You've asked several questions about it, and so I would ask Mr. Miller to brief us on Robert's Rules of Order.
Thank you, Ms. Adamwa. I know we have a lot of board veterans in the room, so some of you could probably give this presentation as well, but I'm going to talk about meeting procedure, not just Robert's Rules of Order, but the broader way in which our meetings are conducted and the rules that apply. And there are three basic sources for our rules. One is the state code that governs all. The second is the city code, and then after that is Robert's Rules. So those are the three sources we look to in determining how our meetings should proceed and actions be taken. So to take a look at the state code provisions, the first one I'm going to mention is 15.22210. Which requires localities to create planning commissions to promote the orderly development of the locality and its environs, and the planning commission shall serve primarily in an advisory capacity to city council. Now that's a substantive provision, not a procedural provision, but I wanted to emphasize it because I want to urge you not to get lost in the procedure aspect. It's very, very important not to let procedure, which will help you keep on the rails with, distract you from your substantive goal of doing your best job for the city and making substantive determinations about uses and zoning. The next Virginia Code provision is 15.22214, and that is what allows us to adopt a meeting schedule at the beginning of the calendar year. So those who have been on the commission for a while know that at the end of the year we set our meeting schedule for the next year, and if there are days like next month, for example, where the first Tuesday of the month is a holiday, we automatically set it for the third Tuesday. This is a state code provision that allows us to do that and set it up all up front. And then there's Virginia Code section 15.2-2215, which has some basic rules like a majority of commission members constitutes a quorum. We have 7 members, so a quorum is 4. And that no planning commission action is valid unless authorized by a majority vote of a quorum. So if you have a quorum, like today we have 4, you need a majority vote to approve something. So it has to be 3 votes out of the 4. City code provisions. The main city code provision is section 2-28. And this is a catch-all list of requirements that applies to all boards and commissions. Like the state code, it says no business shall be transacted without a quorum. It says that no matter shall be deemed approved except by the affirmative vote of the majority of a quorum. It also says no member shall abstain from voting unless, number 1, prohibited by the Virginia State and Local Conflict of Interest Act, or number 2, under the circumstances, voting would constitute an act of impropriety. This is an important provision because what it's really saying is it disfavors abstention by a commission member. You can't abstain if you can't make up your mind, for example. If you have some sort of conflict, some sort of financial interest in an application, some sort of other relationship to the applicant, then in that case abstention may be appropriate, and we are happy to consult with you before or even during the meeting in a sidebar to determine whether or not you actually have a conflict that fits within this abstention requirement, but that's just something to keep in mind. And this same section says that the rules of parliamentary practice set out in Robert's Rules of Order shall govern in all cases to which they are applicable and in which they are not inconsistent with this section. So this is a provision that brings Robert's Rules into our lives. Most other localities have a similar provision. Most of them also rely on Robert's Rules as a backdrop. And now to talk about Robert's Rules themselves. Several years ago, I went to a continuing education presentation by a guy named Walter Irwin, who was the city attorney in Lynchburg. And he had about 30 years of experience, and he said, as part of his presentation, that he likes to emphasize to his council that Robert's rules are to help you. They are a guide. They are not to harm you. They are not to be nervous about. They are not a reason to hinder you in your actions. And I think that was very wise advice. Robert's rules can be very Byzantine, and if you get too wrapped up in the process, you end up going down paths that distract you from that first Virginia Code subsection that I talked about, which is your substantive job to substantively benefit the city in making good land use decisions and recommendations. The other thing to keep in mind about Robert's rules is they are, as anyone who's really read any of them in depth or tried to answer a complicated question knows, they are really built for legislatures. They are built for much larger groups than 7 members. And so while they are helpful and can be useful, don't be afraid of them, and don't feel like you have to absolutely 100% follow the Roberts rules. We will keep you within the legal guidelines, and that's really what you need to worry about. With all that said, with all that criticism of Robert's rules, what they do for you is they do provide a general framework that you can use for your meetings. And so just to walk through a meeting, first thing is the adoption of minutes. Now, technically under Robert's rules, you don't even necessarily have to take a vote on the minutes, but we do, because it's good to have that formal action of the commission. A vote on the minutes, a vote to approve the minutes, is ministerial, meaning it's administrative. It is not an endorsement of what happened at the last meeting. It is simply an acknowledgement that the board has to have official records. And so it does not matter if you are not at the meeting that the minutes address, you can still vote. You don't have to abstain, you can still vote to approve, because what you're doing, again, is administrative only. We adopt the minutes. We move on to a public hearing. At your public hearings, the applicant will come and present. It is perfectly fine for the board to have interaction with the applicant during that process. What you don't want to do necessarily is get into a discussion amongst yourselves, back and forth about how you're going to vote, but having discussion, asking questions of the applicant, that's great. That's part of the purpose of the public hearing. You move on from the public hearing is closed. In order to put a matter on the table for discussion, it's necessary to get a motion and a second to either approve or deny or defer, whatever the board's pleasure would be. So that is, and city councils in the past have done this many different ways, but I think the best practice is to immediately have a motion and a second to dispose of the item. And then when you have that motion, then you can go to discussion of the item amongst yourselves. Form of the motion at the Planning Commission level. We haven't always done this, but technically what you're doing is recommending. You are recommending approval, you are recommending denial. Now, if you forget in the motion as I move to approve or I move to deny, we all know what you mean. We all know what the law says you mean. The council knows what you mean. It's not that big a deal, but technically it should be I move to recommend, or I move to recommend approval, or I move to recommend denial of the motion. Now, if there's a mistake in a motion that needs to be corrected, let's say somebody doesn't say recommend and you want to take care of that, there are 2 ways to address that. The first thing is just call it to the person's attention, and the person who made the motion can change their motion with the consent of the person who seconded it. That's one way to go. The alternative is you can have a motion to amend the motion. If there's a motion to amend, That needs a second, and then you vote on that. When you vote on the motion to amend, all that approves is the amendment. It doesn't approve the underlying motion, so you would then need a second vote on the actual motion if and as amended. Does that make sense?
Yeah. When you say call it out, do we have to go to a formal friendly amendment to the or are we calling a friendly amendment the second portion or the second scenario, or the?
Yeah, the second scenario, well, I mean, either way, if the first scenario, I think if you simply call it to someone's attention, the person who made the motion, and they consent to it, I think that's fine. This is an area, like what I'm talking about. You don't have to get bogged down on exactly who should say what. As long as the person who made the motion consents to it, and the person who seconded consents to it, then the motion is deemed revised accordingly.
I spent the last 4 years as a parliamentarian, so
Yeah, well.
I try not to go down
hand it over to you,
that way
yeah.
when I can.
I'm sorry.
Yeah, thank you.
All right, so you've got a motion on the table. You have your discussion. And then the chair can call for the vote. If the motion was to recommend approval and it passes, then the item's approved. If the motion was to recommend approval and it fails, then the recommendation is denial. That's done. If it's to recommend denial and it passes, then it's done also. The motion is, it's recommendation of denial. But if the motion is to recommend denial and it fails, then you need another motion, because a recommendation to deny is not a recommendation to approve, even if the recommendation to deny fails. So we'll help you on that one if it ever comes up. But that's the one tricky part of the vote.
And just for clarity, so you're saying the most efficient way is to move for acceptance and then vote in the negative?
That's the key.
To deny. Yes.
Right.
Yeah.
Yeah.
Yeah. Or yeah. If you think it's going to get denied. Okay. Once you have a complete vote, let's say later on you determine someone who voted for the item was on the winning side determines that they've changed their mind, and you want to go back and you want to reconsider what the vote was. The motion to do that, a motion to reconsider, has to be made by the person who is on the winning side, and then can be seconded by anybody, and then you would proceed with a vote on that. And if the motion to reconsider passes, then again, you have to have a second vote on the original motion. One thing I did also want to mention, I think I skipped over, is the making of a motion. I think there was some question about whether a chair can make a motion or not. Under strict legislative Roberts rules, no. Under the Roberts rules for smaller bodies, yes.
Okay.
It is not favored unless it makes sense. In other words, you should try to avoid making the motion, but in the particular context we're talking about, you would call for a motion, nobody made a motion, it's perfectly appropriate for a chair to make a motion at that point in
Okay.
time.
Thank you.
Yeah. Then I think all that's left is adjournment. There's no vote required for that. As long as there's no further business pending before the body, the chair can simply note that and adjourn. There's a quick summary. Are there any questions?
It doesn't happen often, but when there's a tie vote,
Thank you.
we have great quorum and, commissioners come, but sometimes you might have a tie vote 3-3.
Yep.
What do you do with a tie vote?
Yep, there's where you go to that state code provision. No planning commission action is valid unless authorized by a majority vote of a
So
quorum.
we had to,
So it denies.
Yeah, fails.
So it was?
it failed.
It fails.
It fails. Thank you.
Thank you for that information, but I believe as always, we can always you're supposed to have, is there any discussion before we take the vote, once the motion is made? And then at that point, a person can say unreadiness on the motion to address what's a concern. I believe that's correct.
Yeah, what should happen is...
I have another question, but go ahead.
Sure, yeah. After you put the matter on the table through a motion and a second, there should be a call for discussion, and the board at that point can discuss the item. And then when the discussion peters out, you move to a vote, you call for vote, and move on.
And then my other question, and because I think many times in our private lives we may violate because we're not supposed to have an official meeting, or more than how many people should be together at a certain place, because then it would be considered an official meeting.
Yes.
Please emphasize that.
Yeah, and that's getting into the state FOIA law.
Yeah.
Under state FOIA, if more than 2 members of a board are together talking about business, that is technically a meeting. And a meeting requires minutes, it requires notice, it requires the formal trappings of a meeting. So yes, if 3 of you were to go to lunch and discuss an item, that would be a violation of FOIA. 2 of you go to lunch, that's fine. 3 of you is a violation.
I think the key point is discuss business, though.
Discuss business.
So we can all come hang out at my house to watch the game this weekend, but we can't talk about planning.
And I wouldn't go there if I were you, but each to his own.
I have one question. Not recently, but when I first started on the Planning Commission, we had a lot of development in the city, and every now and then I would be contacted by a developer who was the applicant, and it kind of caught me off guard on the phone. So I know on more than one occasion I had reached out to staff. Are we supposed to engage with them, hang up on them, or just tell them we're not supposed to discuss anything with them?
I think BZA has a much stricter regimen on that than planning commissions do. I think it's a matter that you all can discuss with staff and determine how you want to respond to that.
That's what I typically do.
That's simply no.
Huh?
I mean, really, you can't do anything without the
I
whole
understand,
board
but
anyway.
it has happened, and when it happened to me the first time, I was new, and I had no idea what to do. It was truly a deer in the headlights, because you don't want to be rude to the person who's calling you, and so I just think it would be a good idea to answer that question. That's why I asked how to handle it.
Yeah.
Commissioners, any other questions? All right. Thank you, Mr. Miller.
Thank you.
Thank you.
Thank you.
Thank you, very informative.
Yeah.
Very good.
Mr. Sweats.
All right, good afternoon, everyone. My name is Brian Sweats. I'm the city's long-range planner, which means I deal a lot with our comprehensive plan. And so I want to give you a presentation today talking about what a comprehensive plan is, and talk a little bit about our comprehensive plan specifically, and answer any questions that you all may have. So first, what is a comprehensive plan? The purpose of it is to promote the planned and orderly development of land. That's the general idea of what a comprehensive plan is. More specifically, it is required under Virginia law that you have that every locality have a comprehensive plan, and that it be updated at least every 5 years. This is a document that is prepared by the Planning Commission, and it's ultimately approved by City Council, but it is really made up of what we hear from Portsmouth citizens and residents. For our comprehensive plan called Build One Portsmouth, we looked specifically at introducing the concept of resiliency into our broader thinking about how the city should proceed. And so I use this little graphic on the right so to kind of better explain what I mean by resiliency. A lot of times when we talk about resiliency in Hampton Roads, we're really talking about how to mitigate impacts from flooding. But in Build One Portsmouth, we're looking at this differently. The idea is that you have a system whereby you use data to identify a problem, We work with the public to identify solutions, try to implement those solutions, and then we go back and review how good of a job do those solutions do at solving the problem that we are attempting to solve. And from that point, you figure out, is there something else that needs to be done, or have we finished satisfactorily? But the idea is that until you have finished, this is an iterative process. This is something that you should keep doing and doing and doing. Think of it like the zoning ordinance, for example. The zoning ordinance is not something that's set in stone, right? We do the best that we can to put together a working zoning ordinance, and then when we identify things that need to be changed for whatever reason, we go back in and we change the zoning ordinance. The same thing should be true for how we run government. As part of this, as part of the outreach efforts for the comprehensive plan starting in about 2016 or so, we went out and we did, I would say, more work with the public than we've done on any other project in the city. We had over 1,800 unique comments in our first round of public input. We spoke with literally hundreds and hundreds of people. We decided that we wanted this plan to look a little bit different from other traditional comprehensive plans. A lot of times if you pick up a city's comprehensive plan, you'll see it's organized by chapters, and each chapter is kind of a different city department. So there might be a schools chapter, there might be a public utilities chapter, an economic development chapter. We wanted to do this a little bit differently. We wanted, instead of focusing on what each individual department does on its own, how do we make departments work together so that the sum is greater than its parts. We were focusing on 3 aspects of resiliency: social, so people and culture; economic resiliency, how do you bounce back from some sort of fiscal disaster; and environmental resiliency, how do you bounce back from some sort of natural hazard. We also wanted to make sure that we addressed sea level rise. Back in 2014, 2015, when we started this whole process, this was a controversial idea in some localities in Hampton Roads. We worked with Old Dominion to do a statistically relevant survey. We talked to over 2,000 people in Portsmouth. We used real scientific rules and regulations and processes to make sure that any group that you can think of, any geographic area you can think of in the city, that they were surveyed appropriately so we could get results that we could actually use, not just a survey that we put on the website that 40 people responded to. We found that over 80% of Portsmouth citizens believe that sea level rise was real. We found that 75% believed that we would see at least 1.5 feet of sea level rise by the year 2050. And while that was surprising for people in other localities when I presented that data, it really shouldn't be much of a surprise here when you think about how much coastline we have, and when you can see the water coming up higher and higher in your backyard every day, it's a lot easier to believe that something is going on. And finally, we wanted to compare the product that we were putting together with best practices based on work done by nationally recognized planners. And so there was a document called the Sustaining Places Scorecard that was put together by the American Planning Association. And what we did was we used that scorecard to guide the way that we set up how we were going to update the plan. We used it to guide the material that we put into the plan, and then we went back and we scored the plan before we released it to the public to make sure that we had hit the things the best practices that planners across the country say that you should look to make sure that you have in your plan. I'm going to go into more specific parts of the plan, but before I do, are there any questions on kind of the broad aspects of? Yep.
And it concerns Norfolk deciding to erect a flood wall. Mm-hmm. And I don't know if you're able to speak to it or not, but it's a great concern to me, because my common sense tells me that when Norfolk erects that flood wall, that pushes water back towards Portsmouth. And I want to know, have we started to address how we can be in a position to counter that flood wall that Norfolk is going to erect?
Well, if I mean, the flood wall implies it's going to go entirely across a river or a body of water, right? Otherwise, the water would
Normally.
just go around.
Yeah, it's going
So
around.
if they were going to try to put something, say, across the Elizabeth River,
No, they're
you'd
going
have to,
around.
then you'd have to,
City.
if it's just out in State River bottom, if it's not touching Portsmouth, there's nothing that we can do from, like a legal perspective to stop them. That would be something that would be dealt with by the Army Corps of Engineers and by the Department of Environmental Quality from a permitting perspective. I cannot speak to the political side of something like that.
Yeah, I guess, and I can speak to a citizen side and say, Norfolk got a grant for this flood wall. And in my opinion, proactively, City of Portsmouth needs to be focusing on how we're going to counteract that flood wall that's going to go around the city of Norfolk, because it's going to impact Portsmouth. We know from previous instances with flooding in downtown, it's definitely going to impact us because it's going to push water back more into the city of Portsmouth. So that's why, I wanted to address that with you.
Sure. Any other questions? Okay, so let's talk about specifics in Build One Portsmouth. So this is an example of how the plan is organized. We have a strategic plan, a geographic plan, an implementation plan, and glossary and appendices all lumped into one document. The strategic plan is the core of the plan. So when you get your staff reports from us, right, and it talks about what the comprehensive plan says, a lot of that is coming out of the strategic plan, where we're looking at what the city's goals are and how we're trying to achieve those goals. From a geographic perspective, in the geographic plan, we have a number of different kinds of maps. I'm going to show you specifically what topics those address. But you can't really have a plan for the city if you're not talking about where you want some of these things to happen. So that's what we attempted to do in the geographic plan. In the implementation plans, how do we actually do these things? And so that gets into some of the tools that we could use, which might include, like, say, grant funding or different departments to work with, or examples of best practices. And finally, at the end, you've got your glossary and your appendices. So explaining what certain words mean or acronyms, and then links to other documents that we used in order to kind of justify what it was that we wanted to put into Build One Portsmouth. Your strategic plan and the section of Build One Portsmouth can be broken down in this way. We started with guiding principles. These were established from the answers that we got from Portsmouth residents to two questions. What do you love most about Portsmouth? And what do you think is Portsmouth's greatest opportunity? And so based on those answers, we distilled down to 4 guiding principles: our pride, our people, our places, and our position. Those are the things that people most commonly were talking about. Then from there, we crafted a vision statement, and we brought that to the public and got their approval. There were 4 main aspects of the vision. They want the city to be thriving, they want to be resilient, they want to be evolving, and they want to be equitable. For each of those 4 topics, we have a list of goals. So for example, if you look on the left here under our thriving vision, the first goal is learning from our unique history and culture. And then underneath those goals, you have strategy and tactics to achieve those goals. So for example, in learning from our unique history and culture, we want to promote modern development that reflects Portsmouth's unique identity. And to do that, we could provide updated design guidelines that blend existing neighborhood and business district character with modern market demands. In the geographic plan, there are 8 different topics that we addressed: character areas, future land use, vacant and underutilized land, historic resources, what we call focus areas, environmental and open space, flood exposure, and citywide connectivity. I'm sorry, that had more than that. So the character areas are basically the aesthetics of the city. What does your neighborhood look like? So if you are in, say, the eastern part of the city, if you're in Old Town, if you're in Prentice Park, if you're in Craddock, you have a much more traditional neighborhood type design. Houses with front porches, narrow lots, streets that are in a grid pattern, for example. you start getting farther west into the city, get out, like say around Elmhurst Avenue or up into Churchland. Now you're looking at more 70s and 80s style traditional suburban development. Future land use, there's 15 or so different categories, most of which are single family, low density residential development, which is what you find in most localities. Most of your land is tied up in low density single family development. But this is where we also identify things like spaces that are appropriate for industrial development, mixed use development, commercial corridors, things of that nature. We used our GIS software to identify vacant and underutilized land. So we used a formula where if a parcel was completely devoid of a building, or if the building was worth less than, I want to say $10,000, or if the building was worth less than like 50% of the value of the land, then that property was considered either vacant or underutilized. And so we use this for economic development so that they can help better figure out where they should be locating some of the projects that they're trying to attract to the city. Historic resources would be things like monuments, cemeteries, historic districts, things along those lines. Our focus areas came directly from the public. We asked people where are places in the city that we should be focusing our attention. And so you can kind of see in the little map here, I wonder why that doesn't work on the screen. Interesting. There are 3 different colors up there. There's yellow, blue, and there's brown. And sorry, this is in the top left map there. Those 3 areas represent neighborhood revitalization areas. What are some neighborhoods that need attention from the city? Strictly residential neighborhoods, mixed-use development corridors, and economic revitalization areas. We mapped out environmental and open space considerations. Some of these are required by the state. Some of these are things that we did on our own. But looking at, say, flood zones, or where are our public boat launches, things like that. We mapped flood exposure, so we looked at what flooding looks like now and what flooding will look like in the future, what we're projecting it to look like in the future. And finally, citywide connectivity relates to transportation. So we're looking at our roads, our bus routes, things like that. The implementation plan tells us what order we should probably be doing things in, how to do them, what tools we can use to try to make that happen. And this is where you can also find a list of all 412 or so different strategies and tactics. And finally, this is what the glossary in the appendix looks like. You can see the links on the right. These are all documents that we used and reviewed to help us figure out how to put together this Build One Portsmouth plan. And finally, to give you an idea of what a page might look like here, you can see, let me stand up to point this out so it's a little bit clearer, but. So T1 represents the thriving chapter. 1 is the very first goal that we have, learning from unique history and culture. A and B represent tactics to try to, represent strategies to try to meet the goal of learning from our unique history and culture. Then you've got your tactics for how to make those happen. We've got a list of the different departments that would be responsible for making that happen. We have maps and links to other documents to give you more information about these strategies and tactics. We have metrics that you could use to judge whether you're successful. And then along the bottom, more in general, these are all links to different parts of the document. We envision this as a tool and not just as a book. So you can link to each of the different chapters: thriving, resilient, economic, equitable. This is where our maps are. This is the implementation section. You've got your table of contents going forwards and backwards in pages, or you can go back to your previous page no matter where it was. All of this, again, was done to try to make it easier for people to use so that after the plan was adopted, anyone could come and pick it up afterwards and figure out more obviously what it was that we were trying to accomplish. If you would like to read a copy of the plan and review a copy, you can go to buildoneportsmouth.org. There's a plan there. It's also on the city's planning page. and I'm happy to answer any questions you all may have.
Thank you, Mr. Swets. Commissioners, any questions?
I do.
Mr. Hines?
Last slide actually said that it was adopted in 2018, so we should be actually coming up on another comprehensive plan soon then.
So not necessarily a new comprehensive plan. The way that the state code reads is it has to be updated.
Okay.
It does not define what update means. So when we did this plan, it was building off of the one that was adopted in 2005, 2006. We decided at that point, because there was no mention of climate change, of sea level rise, flooding, things like this, that we wanted to do a pretty big update, and then really it kind of turned into more of a rewrite. I don't anticipate that we would do that this early. I think that there's still a ton of really good ideas that are in this comprehensive plan that don't need to be thrown away. But it is worth going back and looking at the things that we've accomplished so far, so maybe those get removed. And then to look, talk to new department heads and new planning commissioners and city council members to see if there are any kind of broader things that they want to accomplish that we could put into an updated comprehensive plan.
But by state law, we're required to do an update every 5 then.
Yes.
So we're expecting, when does that start? Because we have an adoption of November 27th.
We are working on that now.
Okay. So in the coming meetings, basically, we'll see these things.
Yes, at some point very soon.
Thank you. Thank you.
Does it say update, or is saying you reassess it every 5 years to determine if you should update it?
I thought it had said updated, but it is, again, it's whatever it says, it's not defined, and there's no penalty. There's no enforcement procedure if you are not updating your comprehensive plan. It's a best practice because this is a plan that's supposed to represent the city, so you want to make sure that you're capturing what both the city large C government is doing and city small c what they want to see.
I think I've tried to put a lot of this out of my mind because we went through a lot building this one back in 2018. I remember the process. But I think to the point of Commissioner Hines, it's going to be critical, I think, also to take into account the changes in society. Post-pandemic has affected the way people operate. So I think that to some point there's some merit in how do we take into account co-working and things like that and the hybrid structure of society today. So I mean, again, kudos to the work that was done back then. It was so well done, and I think we do have opportunity in the future going forward. And I think one of the things I also would love to look at is some of the generational shifts that we may have seen as a city from that time period to now. I know we've dealt with small things such as the explosion of car washes to things that I think are starting to become more of a concern with the casino here now, such as Airbnb and how much of that takes into account in areas such as Newport. So I just look forward to the continued growth of this and appreciate the readiness of this document and encourage us to sing its praises to our fellow citizens so that they too can provide more input on it.
Exactly where I was driving at about the update, because in 2018 that was ancient. You have pre-pandemic and after pandemic, and
It's totally different.
it's a night and day kind of situation. How we conduct business, and even some of our perspectives have changed.
Yeah. So what I would say is that it's important to, when we talk about that, to kind of differentiate between the different parts of the comprehensive plan.
Yeah.
I believe that things like our guiding principles and our visions are things that are probably pretty similar now and then. I think you're seeing more of, like, say, the goals and strategies and tactics that we may need to be updating and looking at again. But I agree that being able to go out and to talk to people and to get their feedback on what we've got is definitely part of this update process.
Right. Thank you.
Question?
Yes, I was just wondering, do we have anything set in place that we could say, okay, let's reevaluate where we come, how far we come within like the last 6 months to a year? Because I know that vacant land use map is probably needing to be updated because
Yep.
the land is not vacant anymore.
Yeah.
So just so that we are aware of how far we come without waiting till we get to that 5-year mark. which
Yeah,
we
and
already
that would be part of the update would be, going back and updating some of the maps, for example, to reflect new changes, things that have developed the last 5 years or so. What was the other one I was going to say? The maps and one of the things that we did when we did this plan that we would do as the update was an audit of the old plan, where we talked to each department and we said, okay, here's a list of the things that was kind of assigned to you in the old comprehensive plan. What has been done? What has not been done, but do you still want to do? What do you not want to do? And maybe what are some new ideas that would go in there? And so part of the update hopefully would be going to the different city departments and doing that exercise again, because we do have a lot of new department heads since we have done this. We've got a new city manager, we have a new council, we have new planning commissioners. So there are going to be changes in priorities, and so making sure that we capture those, because we want this something that's relevant to everyone who's here, not just relevant to the people who were here.
Gotcha.
Okay, thank you, Mr. Sweats.
You're welcome.
Thank you.
Julie, I
Okay.
believe you're next.
Yes, I am. Okay. Good afternoon, Planning Commissioners. I'm going to talk to you about the proposed code amendment to the city's zoning ordinance. So, you can go to the next slide. Thank you. Okay, so since 2021, the BZA has heard over 25 variance applications that dealt with requesting approval, thank you, Brian, to reduce the required side yard setback in order to construct a single-family dwelling on these narrow lots that exist in many areas of the city. The majority of these narrow lots are about 25 to 30 feet, and they're in established neighborhoods such as Brighton, Prentice Park, Ebony Heights. These parcels are typically zoned urban residential, or UR, and the zoning ordinance requires a 7-foot minimum side yard setback when building a detached single-family structure on an interior lot in the UR. Currently, the zoning ordinance does allow flexibility by allowing an applicant to utilize the average side yard setback of neighboring residences on both sides, such that the setback be reduced to no less than 5 feet. And then, so if the setback averaging option is not applicable to the property, or that the applicant wants to reduce the side yard setback to less than 5 feet, then they have the option of applying for a variance currently. The variance land use tool does allow the lot to be individually assessed to determine the impact of reducing that setback on the adjoining properties. So the Code of Virginia outlines several qualifications that must be met in order for a locality's BZA to approve a variance. So one of those requirements states the condition or situation of the property concerned is not of so general or recurring a nature as to make reasonably practicable the formulation of a general regulation to be adopted as an amendment to the ordinance. So that's kind of a mouthful, but basically, because the request for a reduced side yard setback when developing these narrow lots is a relatively common occurrence, it is appropriate to amend the zoning ordinance to provide a more flexible option for relief. So in an effort to determine if an amendment was necessary and discuss possible solutions, as you all are aware, on July 18th, a joint work session was held between the Planning Commission and the Board of Zoning Appeals. At the last Planning Commission meeting, members reached a consensus to allow an applicant to apply for a special exception rather than a variance to request the BZA's approval of a reduced side yard setback. The majority of planning commissioners supported the special exception option because it eliminated the need for an applicant to demonstrate a hardship, but still allowed each case to be reviewed individually. And then at the public hearing portion of the September Planning Commission meeting, you all did adopt a resolution initiating staff to prepare amendments. So on this slide, this shows the proposed zoning ordinance amendment. A special exception may be applied for to modify a required side yard setback for a single-family detached dwelling on a parcel 30 feet or less in width, except where the setback is from a street. So this change would only allows an applicant to apply for a special exception, and it only applies to existing interior lots and if they're developing a single-family detached dwelling. So it cannot be applied for when the setback is from the street. And it only applies to lots that are 30 feet or less in width. So this proposed amendment is intended to provide a more suitable means for obtaining relief when developing a single-family dwelling on a narrow lot. Amending the ordinance to allow an applicant to apply for a special exception allows the Board of Zoning Appeals to assess each special exception application individually to determine if granting the modified side yard setback is appropriate. It should be noted that the BZA does hear both special exception and variance applications, so this will likely not reduce the number of cases that the BZA hears. Although, unlike variance requests, applications for a special exception do not require that the applicant prove that a hardship exists or that the request alleviates a hardship related to the property. So removing the hardship requirement alleviates the burden on the applicant as well as provides a more flexibility to the BZA members in deciding whether to approve or disapprove the proposed special exception. Just a reminder that in approving a special exception, the BZA does have the authority to impose conditions regarding that request, and that allows them to minimize possible adverse effects from the proposed modification. And the current zoning ordinance does have review standards that the BZA looks to when considering applications, and staff does feel that these review standards adequately assist the BZA in determining if a modified side yard is appropriate. And so staff consulted the Permits and Inspections Department regarding building code implications of reducing the side yard setback. And in a single-family dwelling with approval for a side yard setback that is less than 5 feet from the property line would be required to comply with several measures, and those are all verified during the single-family site plan development process, and these measures are intended to protect one building from another in the case of exposure to heat. There was a detailed list of all the requirements that would be applicable if the side yard setback was less than 5 within the staff report. But staff recommends approval of the proposed text amendment to the zoning ordinance to allow applicants to request authorization to reduce the side yard setback for a single-family dwelling on lots that are 30 feet or less in width through a special exception. This change will improve the development process by providing a more flexible and appropriate option for developing existing narrow lots in the city. This concludes my presentation. I'll stand by for any questions that you may have.
Thank you, Ms. Chop.
Appreciate you as always. I get that preface before I zero in. When you used the word assess, you weren't speaking to assess values. You were just speaking to actually evaluating the properties, correct?
Correct.
Then my question is, and this is what I believe should be done, we certainly need to have the city assessor involved in the process, because if I'm hearing you correctly, lots between and being reduced, the areas in between the lot, am I saying that right?
No, the property line would stay the same.
The property line is gonna stay the same?
Yeah, the property line is, you can't, you can only modify that through a subdivision.
But they will be allowed to retrench the size of the edifice that's gonna go on the lot? Is that the
Yes,
interpretation?
so a setback is how far the structure has to be from the property line.
Right, so if it's normally 50 feet, it could be 30 feet. Is that basically what you're saying?
Yes.
So in doing that retrenchment, doesn't that impact the assessed values for the building itself? Because instead of a footprint that goes to 50 feet, I'm just using an example, it would now be allowed, with an exception, to be 30 feet. So doesn't that impact the assessed value in some way? You don't know the answer.
I don't know, but I think that it doesn't apply to, right now we're looking at the land use. So I think that if somebody chooses to build a house that is 5 feet from the property line or 3 feet from the property line, like, that's not the.
Well, if we could investigate it further with the assessor's office, because I think it is going to impact on assessed values if you're retrenching the size of the building on the lot. I guess that's what I'm saying.
I guess I'm not understanding, because the applicant is requesting that, like, it's their choice whether they ask for this. So if it's affecting their assessed value, then that's their problem.
They may not know that. And so,
Okay, let's let.
Did you understand that you have a 25-foot lot, which is a
Right.
non-conforming lot?
right,
That a person may not be able to develop the lot.
Anything.
So the ordinance says, for the most part, you need a 7-foot side yard on each side.
right.
And because the lot is so narrow, 7 foot will make the house extremely small. So he's asking maybe,
Shotgun house. Go ahead.
not 7, maybe give me 5. Or in some cases, maybe give me 3. And that allows him to have a larger house, a house that he can sell. This would improve the community with this new house in the community. So if anything, the assessed values in the community would go up.
Except, suppose it's an existing lot
It is an existing lot.
with a house on it already that is per.
The setbacks are already established if it's already there.
Allow me to continue, please. Okay. If you have an existing lot and it's got a building on it that is code compliance at the moment based on what the code required before, and that person wants to tear down that building and build a structure that is smaller under a special exception, does that not impact the assessed value negatively? Is the question.
I don't think that
it
if
was
they
something new.
met the side yard setbacks before,
They tear
then
down the structure.
yeah,
Didn't
but
need an
then
exception either.
why? I don't think that the special exception. That's exactly why the BZA would evaluate that and say, hey, if you could meet the setbacks before, then you can meet them now. So they wouldn't approve that request, or I wouldn't think that they would approve that
You
request.
second guessing. Okay, I guess I would say this. We will agree to disagree on that because I think there is an impact. And the other thing I would ask, and this is to all of the planning staff, because we have people tuning in to the presentations, let's refrain from using the acronyms because I know what a BZA is, but those who are viewing in may not know what BZA is. So if we can please refrain from using acronyms in our presentations, I think that is the way to be more audience friendly, more citizens friendly. Thank you so much.
Yes, ma'am.
Commissioners, yes, sir. Commissioner Hines.
Thank you, ma'am. So actually, this probably might be to Mr. Miller. When we had our meeting with the Board of Zoning Appeals, there was a discussion about the code that you cited about the variances, essentially possibly trying to change the code. The special exception, nowhere mentioned in state code that they can approve as many as they want to without any impact on the zoning ordinance, correct? And that's currently in place.
That's correct. A special exception is essentially a mini use permit. It's legislative in nature as opposed to variance, which is quasi-judicial and is much stricter.
Right, so we're essentially, as we're writing this particular code amendment, we're almost kind of handing over the keys of the legislative side of our job when it comes to this portion of our business.
Yes, well, it's to an area where the BZA generally acts, which is on the dimensional stuff, and that's why the special exception vehicle goes to the BZA, because it's dimensional, as opposed to really your more focused generally on land use, zoning.
Again, I've got no problem with that, but I'm saying this out loud so that our Board of Zoning Appeals is now hearing that we're giving this legislative power to where now they can feel freer than what they have in the past.
Yes, sir.
Okay. So it's more of a statement than a question.
Not BZA, but Board of Zoning Appeals.
I did say, started out with Board of Zoning Appeals.
No, I'm talking to Attorney Miller.
Yes, ma'am.
Okay.
Thank you for your work with this, by the way.
Thank you.
Thank you, Julie. Mr. Milner, I believe you have one more quick item.
Yeah, there will be one additional resolution for you all to consider at your meeting, and that is to initiate another zoning amendment. This relates to correctional facilities. City staff's been evaluating the zoning terms related to correctional facilities, and currently, with a use permit, you're authorized to either have a public or private correctional facility. Private correctional facilities are not a particularly beneficial use for the city from a tax standpoint or a number of other standpoints. And so staff is asking you to initiate an amendment, which staff would bring back to you at your next meeting for a vote, to eliminate private correctional facilities from use permit approval process in the city.
Okay. Thank you.
Can I just ask one?
Mr.
We would have ourselves a public hearing similar to every other process.
It would be, yeah,
So
it
if
would be
anybody
just
has
like this one
concerns.
that's going today.
Okay.
Yes, sir.
Sounds good.
Just one quick question. As we prepare for this, do we currently have any?
No.
Okay. Just verified. I was like, I don't think of it.
Being proactive.
Yes. Okay, thank you, everybody. If there's nothing else, we will convene for our regular session at 1:30. Meeting adjourned. Good afternoon, ladies and gentlemen. I would like to welcome you all to this very important meeting today, Tuesday, October the 3rd, 2023, in the City of Portsmouth City Council chambers. Madam Secretary.
Thank you, Madam Chairman. Commissioners, we will now have roll call. Please indicate your presence electronically. Six members of the Planning Commission are present.
Is that me or you?
Commissioners, that's you.
Commissioners, before you are the minutes of the September 5th, 2023 public hearing. If there aren't any changes, we are in need of a motion. G, oh, no, electronically. Is there a second?
Are we doing that now? Oh,
We need a motion
Oh.
first.
I was waiting to be recognized. I move for acceptance of the minutes as presented.
Thank you.
Second.
Thank you.
Okay.
Madam Secretary.
Thank you, Madam Chairman. We have a motion and a second to approve the minutes from the September the 5th, 2023 public hearing, and you will be voting electronically. The minutes are approved by a vote of 6-0. Announcements of future meetings and conferences. Due to the statewide elections, our next scheduled work session is Tuesday, November the 21st, 2023 at 12:30 p.m. City Council Conference Room, followed by public hearing at 1:30 p.m. City Council Chamber. Items reviewed today will be presented to City Council for action at their November the 14th, 2023 public hearing or as otherwise noted. Planning Commission rules limit a speaker up to 5 minutes to speak. We also ask that everyone please silence your cell phones at this time if you have not already done so. Our first item, CA-23-02 citywide. The City of Portsmouth proposes to amend City Code Chapter 40.2 zoning ordinance to allow an applicant to apply for a special exception to request modification of the required side yard setback for a single-family detached dwelling on a lot that is 30 feet or less in width. The staff coordinator is Julie Chop. Ms. Chop, will you please come forward and present your application at this time?
Good afternoon, Planning Commissioners. Please bear with me as I give this presentation again so that it is on the record. I am Julie Chop, Principal Planner with the City of Portsmouth. This presentation will provide details on the proposed text amendment to the city's zoning ordinance. Since 2021, the Board of Zoning Appeals has heard over 25 variance applications requesting approval to reduce a required side yard setback in order to construct a single-family dwelling on narrow lots that exist in many areas of the city. The majority of these narrow lots are typically 25 to 30 feet wide, are located in established neighborhoods such as Brighton, Prentice Park, and Ebony Heights, and are usually zoned urban residential UR. The city zoning ordinance requires a 7-foot minimum side yard setback when building a detached single-family dwelling on an interior lot in the UR zoning district. Currently, the zoning ordinance allows flexibility by allowing an applicant to utilize the average side yard setback of neighboring residences on both sides, provided that the side yard setback is no less or is at least 5 feet. If the setback averaging option is not applicable to the property, or if the applicant wants to request a side yard setback that is less than 5 feet, an applicant has the option of applying for a variance to request the BZA's approval of a reduced setback. The variance land use tool allows the lot to be individually assessed or to be evaluated individually to determine the impact reducing the setback would have on the abutting properties. The Code of Virginia outlines several qualifications that must be met in order for a locality's Board of Zoning Appeals to approve a variance request. The third requirement states the condition or situation of the property concerned is not of so general or recurring a nature as to make reasonably practicable the formulation of a general regulation to be adopted as an amendment to the ordinance. Basically, because this request for a reduced side yard setback has become a relatively common occurrence, it is appropriate to amend the zoning ordinance to provide an alternative option. In an effort to determine if a zoning ordinance amendment was warranted and to discuss possible solutions, a joint work session was held with the Board of Zoning Appeals and the Planning Commission on July 18th, 2023. At the September 5th Planning Commission meeting, Planning Commission members reached a consensus to allow an applicant to apply for a special exception rather than a variance to request the Board of Zoning Appeals approval of a side yard setback. The majority of the Planning Commission members supported the special exception option because it eliminated the need for the applicant to demonstrate a hardship while still allowing each case to be heard individually. At the public hearing portion of the September Public Planning Commission meeting, a resolution was adopted initiating staff to prepare amendments to the zoning ordinance that address the narrow lot side yard setback issue. The proposed zoning ordinance amendment language is shown on this slide. This change allows an applicant to apply for a special exception to request the Board of Zoning Appeals approval of a reduced side yard setback for a single family on a narrow lot. This provision only applies to side yard setbacks on existing interior lots for the development of a single-family detached dwelling, and may not be applied for to modify a required street side yard setback. This special exception option is only applicable to lots that are 30 feet or less in width. This proposed amendment is intended to provide a more suitable means for obtaining relief when developing a single-family dwelling on a narrow lot. Amending the ordinance to allow an applicant to apply for a special exception allows the Board of Zoning Appeals to review each special exception application individually to determine if granting the modified side yard setback is suitable. It should be noted that the BZA hears both special exception and variance applications, so this will likely not reduce the number of applications that are heard by the BZA. However, unlike variance requests, applications for a special exception do not require that the applicant prove that the request alleviates a hardship. Removing the requirement to prove a hardship alleviates the burden on the applicant and provides more flexibility to the BZA members in deciding whether to approve or disapprove the special exception request. In approving a special exception, the BZA has the authority to impose conditions regarding the application to minimize adverse effects from the proposed modification and to ensure compliance with the general intent of the zoning ordinance. Staff feels that the existing review standards within the special exception subsection of the zoning ordinance appropriately assist the BZA in making determinations for special exception requests to modify a side yard setback on a narrow lot. Staff did consult the Department of Permits and Inspections regarding building code implications of this change. A single-family dwelling with approval for a side yard setback that is less than 5 feet from the property line would be required to comply with several measures that are intended to protect the building from a adjacent building in case of exposure to heat. These measures would be evaluated for compliance during the single-family site plan development process. Staff recommends approval of the proposed text amendment to the zoning ordinance to allow applicants to request authorization to reduce the side yard setback for a single-family dwelling on lots that are 30 feet or less in width through the land use regulation tool of special exception. This change will improve the development process by providing a more flexible and appropriate option for developing existing narrow lots in the city. This concludes my presentation, and I will now stand by for any questions from the commissioners.
Thank you, Ms. Chop. Commissioners, are there any questions for Ms. Chop? Commissioner Jiggets?
Yes, I just wanted to again say, using the actual words instead of acronyms. So instead of BZA, Board of Zoning Appeal, just to help our viewing public so that they know what we're talking about at every step of the way. Thank you so much.
Thank you.
Commissioner Hines?
I just want to take a moment and thank the planning staff for hearing, and not just hearing, but also going the next step to assist the Board of Zoning Appeals to have the ability to do the job they were placed to do, which is to not only be able to hear the appeal, but also apply facts to the particular case. I believe this legislative action by this group will allow them to be able to make the necessary decisions on a case-by-case basis. So I just wanted to thank you for not only hearing that concern that went to council, then also the concerns that the Board of Zoning Appeals had with us, and also for being very inclusive in the process. I just wanted to thank you and staff for that.
Commissioners, any additional questions? No? Okay. Thank you, Ms. Chop. Madam Secretary?
Thank you, Madam Chairman. Ladies and gentlemen, this is a public hearing on item CA-23-02. If there is anyone here who did not get an opportunity to register and would like to address this application, you may come forward, state your name and your address for the record, and you will have up to 5 minutes.
My name is Gary Bunning, live at 416 K Road in Park Manor. I'm also the chairman of the Board of Zoning Appeals, and Mr. Hines took a lot of my thunder. My main thing that I wanted to do was to express my appreciation to the planning staff for hearing our concerns with the number of applications we've had. This amendment will take away some of the rigorous requirements that are in a variance and allow us to make decisions on what's best for each case. And it also should allow us to allow for development on some lots that previously were undevelopable. They were just too small to build anything on, so they wound up being vacant lots and just sitting. So at any rate, I'm fully in support of this amendment. But I mainly wanted to express my appreciation to planning staff. Thank you.
Thank you, Mr. Bunting. Madam Secretary?
Is there anyone else who would like to address CA-23-02? You may come forward now, state your name and your address for the record, and you will have up to 5 minutes to speak. Appearing to be none, Madam Chairman, members of the Planning Commission, this public hearing is now closed. Need a motion?
Is there any more discussion? If not, we are in need of a motion and a second.
Madam Chair, Lady, I move to approve CA-23-02 with, are there any conditions in that? No?
No, sir.
I make a motion to approve.
I'll second.
Commissioner Hines?
He
Commissioner Hines, second.
Okay.
Commissioner Hines, okay.
We got Hines. She got G name up there. Okay.
Okay.
Okay. We have a motion and a second to approve CA-23-02, and you will be voting electronically. This item is approved by a vote of...
Are you waiting on me?
No.
Thank you, Madam Chair, Lady.
Okay. Jiggets was out, was a no. So it's 5. It's 5, 6-0, or 6-1. The vote is 6-1. Okay.
New business.
Yeah, okay. Our new business, resolution to initiate staff to prepare draft amendments to the zoning ordinance to address removal of privately operated correctional facilities from the definition of the correctional facility use, prohibition of privately operated correctional facilities within the city, and such additional modifications as may be deemed appropriate.
Madam Chairman, from time to time, the city will reassess the zoning ordinance and various land uses. The city has looked at the current situation with correctional facilities and has determined that they want to prohibit private correctional facilities. We don't have them in the city now, but we're planning for the future, so we want to change the code, amend the code, that we do not allow private correctional facilities. And that's why you have the resolution before you.
Okay, thank you. Commissioners, any questions? Okay, so we will need a motion to allow staff to prepare draft amendments and a second.
I move that we approve a resolution to initiate staff to prepare draft amendments to the Portsmouth zoning ordinance to address removal of privately operated correctional facilities.
Second.
Thank you. Madam Secretary.
Thank you, Madam Chairman. We have a motion and a second to allow staff to prepare amendments to the zoning ordinance, and we will be voting electronically. This item, did you? You voted incorrectly. We have a commissioner that didn't mean to vote the way that she did. Do we need to start over? Can we change her vote now?
Yeah, I would consider it just an erroneous.
Okay. Okay.
Okay.
Thank you. Yes, ma'am.
Is the board working or it's not working?
It's working.
Okay, because I don't see anything up there.
You haven't voted yet. As soon as you vote, it comes on the screen. It wasn't you, it was someone else. We have to re-vote again. You want to talk to her?
Ms. Jiggets, thank you. Yeah, we're just going to re-vote again.
This item is approved by a vote of 6-0. Thank you, Commissioners.
Madam Secretary, I believe that concludes our agenda for today. Is that correct?
That is correct.
Commissioners, will there be any further business? None? Ms. Adamwa, any additional?
Yes, I'd like to note that senior planner Amy Mervine, this is her last meeting. She has resigned Friday, her last day. I'd just like to, if she's here, to thank her for her service to the city of Portsmouth.
Thank you, Ms.
you,
Marvine.
It's been such a pleasure working with all of you.
Thank you. If there's no further business, this hearing or meeting is now adjourned.